Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air here. Well, I guess I've got some enthusiasts out there that are USC fans, and I'm sure there's some UCLA fans out there as well. And got an email asking me my opinion about the Steve Sarkisian lawsuit. Now, for those of you who don't know who Steve Sarkisian is, he was the USC football coach that got fired on October 12th, 2015. And the reason why he got fired, I'll bring up in a second, but he's basically challenging his termination. He's actually filed a lawsuit, and they're asking me my opinion about it. And the question is presented as whether alcoholics are a protected class, because I guess he's a self-admitted alcoholic, and he had some issues, I guess, at work, meaning, on the football field and the locker rooms and a few other places. And I guess as a result of that behavior, it looks like USC made the decision to fire him. Now, for those of you who don't know, he's the head football coach at USC, or at least he was. Now, his allegation is that USC violated state disability and discrimination laws by terminating him because of he's claiming he has a disability, and that UCLA failed to accommodate his disability, which he's claiming is in fact alcoholism. Now, we have to keep in mind that the ADA, that's what the Americans with Disability Act, does protect alcoholism as a disability. On the other hand, there's a line to be drawn between protected addiction and unprotected on-the-job misconduct, even when the former causes the latter. In other words, an employer may require an employee who acknowledges that he or she is an alcoholic to meet the same standards of performance and conduct as applied to other employees. And quite simply, they don't get a free pass. Now, I want to emphasize that this is on the ADA, which is federal. This is federal. He filed in state court. Now, let's look at this. Let me give you an example. An employer does not have to tolerate poor job performance or unsatisfactory behavior such as absenteeism, tardiness, or insubordination, or on-the-job accidents related to an employee's alcoholism if similar performance or conduct would not be acceptable for other employees, meaning they keep them all at the same standard. If the employee does violate any of these noted infractions, the employer can discipline the employee. And I will stress, please put it in writing, even if the conduct stems from alcoholism. Now, the reason why this is coming up, and I actually did a blog on this a few weeks back, is because, again, I get these inquiries regarding these things, and some people don't read the blog, but they listen to the podcast. And I've gotten a couple of emails since then regarding alcoholism and drug addiction. Well, alcoholism and drug addiction can impact so many work environments, and employers get lost as in terms of what their obligation is. So as I told you, the ADA is a federal protection, but I want to stress that Sarkisian was a California employee. So I do feel compelled to discuss California law regarding somebody who admits that they're an alcoholic, or maybe they're under a controlled substance and they have an addiction. So under the California Labor Code, if an employee acknowledges that they have an addiction to drugs or alcohol, the employer should back away from a termination and advise the employees that they're eligible for a 30-day unpaid leave of absence. Now, this is in the California Labor Code. So now you're talking about somebody that's admitted it. So if you were in the process of terminating them, you would back away from the termination. You would turn around and give them an opportunity to get into a program if they're choosing. Now, that rehab program is not paid for by the employer. It's paid for by the employee. If the employer has a health care program and the employee and the employers health insurance program has what they call an employee assistance program. We call it EAP. They have an employee assistance program. Then the person can take advantage of that program through the health insurance carrier, and that would be good. Now, if there's no EAP available, then they would have to find one on their own at their own expense. Now, look, when the employee returns from that leave of absence, they need to be told by the employer four things. The first thing they need to be told is that they've got to comply with the program, the rehab program that they're in. The second thing that they need to be told is that they have to adhere to all company policies, so such as getting to work on time, whatever the case may be, because they may have had an issue with getting to work or getting to work on time. The third thing that they have to understand, that you can tell them, and put this all in writing, by the way, is that they will be subject to random testing. Number four, if they don't comply with the testing, or they refuse to comply with the testing request, then they can be subject to immediate termination. You put all of that in writing, and you say that it's a condition of your continued employment. You have to comply in these four areas and have them sign off on it. Now, that's the generally accepted practices out there. That may vary slightly, and always talk to counsel or whoever advises you in case, your policies might be different, or in case somebody wants to advise you differently. These are just my opinions, obviously, based upon my own experience. And again, I would make sure this is all in writing. Now, look, I want to give you a reminder. You may impose the same discipline that you would for any other employee who fails to meet performance standards or who violates a uniformly applied conduct rule. If the appropriate disciplinary action is termination, now going back to the ADA for a second, the ADA would not require further discussion about the employee's disability or request for accommodation. An employee whose poor performance or conduct is attributed to alcoholism may be entitled to a reasonable accommodation separate from any disciplinary action the employer chooses to impose, and assuming the discipline for the infraction is not termination. If the employee only mentions the alcoholism but makes no request for an accommodation, the employer may ask the employee if the employee in fact believes an accommodation would prevent further problems with performance or conduct. If the employee requests an accommodation, the employer should begin an interactive process to determine if an accommodation is needed to correct the problem. And that accommodation obviously would have to be something about letting them have some time off to be able to get into a rehab program or whatever. Now, this discussion may include questions about the connection between the alcoholism and the performance or conduct problem. And that would make sense. Look, everybody cannot perform when they're necessarily under the influence of a controlled substance or alcohol, but some people can. So, understand that as an employer, you still have a right to be able to double check with if you have a reasonable suspicion that the person is under a controlled substance or alcohol, then you have a right to have them sent out and tested. I would encourage you to make sure that you have a proper drug and alcohol policy in effect that specifically states those two things. And again, one being that if you have a reasonable suspicion, or the other one being that in the event of a workplace accident, that you'll also send the person out for testing. And let them know that when they get sent out for the testing, that in fact, if it comes back positive, they could be subject to termination. Now look, the other thing I want you to do is make sure that if somebody really seems to be under the influence of one of these two situations, that somebody actually drives them to the facility to be tested. Because you don't want them to have an accident on the way, and now all of a sudden, you've got another issue of liability on your hands. Now, the ADA, if an employer has been warned as an example several times for tardiness, you can tell them that the next time they're tardy, you issue a written warning stating that one more late arrival will result in termination. That's perfectly fine. You can do that. Remember, all you're doing is giving them an opportunity. If they don't take the opportunity by continuing to fail in their responsibilities towards the employer and its policies, practices, and procedures, then you're permitted to take some further action. Now, I'll tell you the problem I see for USC. It's the timing. And the reason why I say that is because Sarkeesian's termination had, at the time that they terminated him, they knew that he was on his way to go to a rehab center they had already granted him a leave of absence. So in essence, while he was on the leave of absence, on the way to the rehab center, they contact him and tell him he's fired. Now, under California, that could be problematic. But then again, we don't know what happened behind the scenes. Behind the scenes, something else could have happened, and they had to make the decision that they had to make. Time will tell. I will keep you posted on that. All right, with that last comment, it's time to close out this segment. But let me remind you, you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Excuse me. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. Just call us between 9:45 a.m. and 10:45. If you don't want to call because you're too shy, well, here's what you do. Email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thank you so much for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.